Our next speaker is Professor Sharkey. Catherine Sharkey is a professor of law at the New York University School of Law, where she is one of the nation's leading authorities on federal preemption and products liability law. Her scholarship has been cited by numerous federal appellate and trial courts. Most recently, her work was cited by Justice Ruth Bader Ginsburg in her dissent in Regal versus Medtronic on the issue of the relationship between a product manufacturer's compliance with federal safety regulation and its potential exposure to tort liability. She will join Professor Richard Epstein as co-author of one of the leading torts case books and is a co-editor with Professor Saul Levmore of the second edition of Foundations of Tort Law. Professor Sharkey earned her bachelor's degree in economics summa cum laude from Yale. She also earned her law degree from Yale and obtained a Master's of Science in Economics for Development with distinction from Oxford. She clerked for Judge Guido Calabrese on the Second Circuit and Justice David Souter on the Supreme Court. Professor Sharkey.
Thank you, Judge. As you can tell from my short bio, if my talk on preemption were that I stand where I sit, it would be very boring because I sit in the academy, so I don't have a particular client-driven position on this. But I do want to pick up on what both Michael and Alan were saying. First, I think preemption, to me, is such a fascinating area because it involves Congress, the courts, and agencies. Unlike Alan, I think I don't put a lot of faith or stock in Congress. I think Congress has repeatedly punted on the issue of preemption, and courts, federal and state courts, face these issues and have to address them. And the main drive of my work has been trying to figure out an analytic framework for courts to use in this area that, as Alan pointed out, is a muddle or is in chaos. I think this matters because in the work that I've done, particularly in products liability preemption and with specific focus in the pharmaceutical and medical device area, you can actually see that particularly differences between state and federal courts who are following different analytic models in this case can lead to very different kinds of outcomes. And for example, the idea that state and federal courts are both interpreting the same federal statute but would follow very different analytic models seems worthy of discussion. The two factors, I guess, that I'd like to put on the table that maybe, I can't say they're explanatory factors from Michael's study, but they might be worth talking about, are one, the presumption against preemption, and two, the role of the underlying federal agency. So on the presumption against preemption, what's interesting is that this gets trotted out as a kind of default statutory interpretation canon. One would have thought that maybe judges would need this kind of default presumption in cases of implied preemption as opposed to express preemption. But in the products area, at least, that presumption gets trotted out more often in the express versus implied cases. So that could be, again, I'm just being sort of speculative and provocative in response to his slides, but that could be an underlying kind of explanation that might explain liberals being less likely to find preemption in the express preemption context. I find the presumption against preemption extremely problematic. It's deployed very haphazardly. It seems to be trotted out in certain cases and mysteriously missing in others. Many scholars and commentators have sort of agreed and then said, so what? I like the agreement. I don't like the so what. The so what matters because, again, in particular, in case studies that I've done, you can see how this could become outcome determinative. And in particular, I've discerned at least some slight differences between state and federal courts in the area of drug preemption, and the state courts seem more likely to be deploying the presumption against preemption and more likely to be giving it definitive weight. And so we should have, my argument is basically as an analytic model, we should decide whether or not this presumption against preemption should exist, what kind of weight it should have, and it shouldn't differ between, say, state and federal court judges. My own normative view is that I don't see any reason why we should have a presumption against preemption. There are certain arguments about political process that, for example, if you have a strong anti-preemption default rule. This would lead to better discussion, putting the issue before Congress. I started my remarks with my lack of putting too much stock in Congress solving these particular issues, but I guess in general my response to that argument is you could likewise have a very strong default rule that would be pro-preemption, and likewise you would energize various actors to come out of the woodwork and debate the issue if that were your main desire. So I think that the presumption against preemption doesn't help us that much. The second factor I want to just mention, the position of the underlying federal agency. In the products liability cases, this has turned out to be a significant factor. In fact, in every products liability case, starting with chip alone up to the present, with a couple exceptions that I'll mention, the end position of the U.S. Supreme Court, whether it found in favor of preemption or against preemption, aligned with the underlying view pushed before it by the federal agency. In some of the cases, there was kind of cryptic reference to that by the U.S. Supreme Court. The U.S. Supreme Court has repeatedly ducked the issue about whether or not an agency's position on preemption should get Chevron or mandatory deference or something more akin to Skidmore power of persuasion. They alluded to the latter in Wyeth, but they, in Cuomo, for example, the banking case where they could have addressed this issue, they decided not to. In Waters versus Wachovia, a previous banking case, they decided not to address it. I think that factor is showing some of the fractured nature of what's possibly going on also behind some of Michael's findings there. In other words, this is an issue on which those justices are very, very divided. My own normative view, just to end on this one, is that I think these questions of preemptions are going to fall in the hands of courts. I think that having kind of peons for let Congress solve these problems aren't going to get us anywhere. While it's true Congress may not originally in the 60s and 70s when enacting some of these statutes thought about these issues, as they've been amended and as they're on the table today with rife tort litigation in the background, they're still not addressing the kind of regulatory interplay. So courts are going to have to handle these kinds of issues. I think they shouldn't rely on a presumption against preemption. I think they should look squarely at the issue of whether the regulating federal agency has regulated the precise risk that the state tort law would be trying to regulate as well, and in those instances, there should be preemption. So I think they should take seriously the information that comes before them from the agency. By this, I don't mean just a litigation position, whatever the agency says. I think you look into the record of the regulating agency and you look to the regulatory review. And in those instances, again, where basically the state tort law claim would be duplicating that, you would have preemption, and otherwise you would not. I would argue that Wyeth leaves that kind of review open and in fact maybe encourages it to some extent. And I think that this would lead to, if this were followed as a kind of framework, it would lead to a kind of rationality being imposed on both state and federal courts as they are doing this kind of statutory interpretation. Thank you.